Okay, welcome to K-Talk. I am Dan O'Gorman. I am an associate professor at Barry University School of Law.
And I'm Steve Maxwell. I am unemployed and about to become the Director of Academic Achievement and lecturer in law at University of Miami.
And I'm glad you mentioned that, Steve, because stating you're currently unemployed, people might wonder why I had asked you to co-host a podcast on contract law if you're currently unemployed. But so glad to know that you'll soon be employed.
Well, I'm between contracts, actually.
You're between jobs.
Irony here.
I'm between jobs. So K-Talk is a podcast that is targeted at first-year law students who, I think, Steve, it's fair to say that every first-year law student in the U.S. has to take contracts, isn't it?
I think that's right. I don't know of a school, Miami will be my third school. Everybody is, I don't know. I think it's also fair to say that every first year student struggles in contracts. Very, very few people really take to it like fish in water. I think it's one of those that it's an acquired taste. At least from my experience. And I'll give full disclosure here that my first semester, and I better tell you that I was one of Professor O'Gorman's students. I believe it was his first year teaching contracts to 1Ls, and I was a 1L in his first contracts class. And I was confused out of my mind. And I even had a background. I was an economics major in undergrad. And so it was a very, very strange dynamic. And another very embarrassing full disclosure, I got a C+ that first semester. And so I think that's a testament to how different it can feel transitioning, not just from, non-law school to law school, but also into contracts. And so it's a double confusing course, in my opinion.
Well, I hope your confusion is not a reflection of my teaching ability, but and we'll probably do a podcast down the road, assuming that this pilot were picked up, because this is the pilot episode. We'll see if we're picked up by the networks. But we'll probably do a podcast down the road about academic success in law school, because one of the reasons why I asked Steve to join me on this podcast is because Steve really showed how somebody who is very bright, as most law students are, and who can work very hard and has a great work ethic, still might not see the success that they hoped for in that first semester of law school, because it is so different. And he figured out, basically, is it wrong to say how to play the game in a sense of what makes for a good law school exam? And he turned it around and ended up graduating third. See, you would have been number one if it hadn't been for that C+ I gave you. But that is water under the bridge. And
it only took me 10 years to get over that.
I'm good to know you're fine. Me asking you to co-host this podcast has finally gotten you over it. So yeah, this is my mea culpa. And a secret is that when professors learn that some of these great students don't do well in just their class, you start to wonder, is it them or might it be me? But so I asked Steve to join me on this podcast. He's not a contracts expert, but he knows a lot about contract law because Steve has been doing academic success and bar prep work at law schools for a long time now, which means that you know a little bit of a lot of areas of law, including contracts. And what Steve is probably going to do here is play a bit of the role of the student, in the sense that he knows the kind of questions that students often ask, what confuses students, and I'll sort of play the role of the contracts expert. It's just a role. I will play the role of the contracts expert, and hopefully these podcasts will help you, the first year law student, understand contract law, make it not as confusing as it was for someone like Steve and many others. So the first topic that we are going to cover, and what we're calling the Blackletter series, is sources of contract law. Now, Steve, did we picked this right because this is such an exciting area of contract law? What Article 2 versus UCC, is that fair to say? I mean, Article 2 versus
Yes, titillating. Most students really crave, you know, I remember actually thinking, gosh, why don't we have some sort of uniform law in here? Why do we have two different, kind of a decision tree to make at the beginning of our essay? You know, why do we have to do that? Why is it so complicated? And then I think, gosh, it makes a lot of sense if we want to make money in practicing law. It needs to be somewhat confusing.
That's right. I mean, students, you bring up a good point. Students, so what I see what you're saying. Where are you going with this? You're encouraging students that when they're struggling with the confusion of law, they should remember this is what's going to get them a job down the road. Is that what you're saying?
That's right. If anyone could do this, there'd be not enough employment. And speaking as an unemployed individual, I think that's very important.
Hey, you're between jobs. You're temporarily unemployed. Okay, so as you can see, I'm sharing a PowerPoint here. I hate PowerPoint, but my understanding is students like them. So we're playing to the audience, and we've got a PowerPoint here. So sources of law. And Steve, you'd mentioned how you said, well, why can't there just be a single source of law? And this is something that is probably going to be a bit confusing to the starting law student, which is in some courses, there will be different sources of law that will apply based upon the type of issues involved. And I think in your first year courses, you might see that with criminal law, perhaps, where what you see the model penal code. I remember I studied New York law and the model penal code. But contract law is an example where most likely you will have to recognize that there are two different possible sources of law to resolve a particular contract dispute. And I like to start out with this as the first thing I teach. I know it's not terribly exciting, but I like to teach this first because it seems to me sort of the first fundamental question. Okay, I've got a legal issue in front of me. I need to try to figure out what the result would be applying the law to this set of facts. And the first thing I would think you'd want to know is, okay, if there's multiple sources of law that might apply, which one applies to this particular transaction? Steve, you're a bar prep expert. This is pretty important for bar prep as well. And I know that for a lot of our students, this is down the road. But source of law for contracts is an important issue when you're taking the bar exam if you get a contracts essay. Is that fair to say?
Very fair. And in fact, and one of my big mistakes my first semester was not thinking about how this is going to play out on an essay and an exam. If my professor gives me the fact pattern, how am I going to deal with this issue? And on the bar exam, it's very, very helpful if you deal with this choice of law issue first. I consider it what I call a threshold issue. Once this issue is decided, then the essay sort of writes itself because you're not sitting there dealing with two choices of law on every subsequent issue in your essay. You're not sitting there talking both sides of your mouth. You're just dealing with this issue, and then you just run with that choice of law. If it's Uniform Commercial Code, we go this way. If it's common law, we go this way. But if you sit there and deal with an issue and then talk about the choice of law within that issue, things get muddled and students don't write well, and they mix issues and they blend things and they confuse themselves, and they demonstrate that to the professor. So I think it's very, very helpful to go ahead and decide this initially at the threshold. And your prof can throw a couple of curveballs at you. They can throw 2 or 3 different distinct contracts at you in the fact pattern. Mm-hmm. And this is just a threshold issue you want to take care of at the onset, deal with that contract, then deal with this issue again vis-a-vis the second contract, and then vis-a-vis the third contract, and keep them separate so that you're not constantly dealing with this issue throughout the rest of your writing.
Steve, you're scaring the students. You're talking two or three different contracts at a single fact pattern. All right, everyone relax out there. Just stay calm. And we'll probably have a podcast down the road, again, if we're picked up on examsmanship and things that you should be doing on an exam. But okay, so let's talk about this source of law issue. So since this is focused on first-year students, we're going to talk briefly about some basic things, which for people who are upper-level students, this would be pretty basic for them, but incoming students might not understand this. And the first thing is that when you're dealing with contract law, you're almost always going to be dealing with state law rather than federal law. So every state has its own rules of contract law. Now, fortunately, those rules tend to be pretty much the same. There's certainly some differences, but they're pretty much the same. And it's that state law, we rarely talk about, say, the law in Nebraska or law in Missouri. We just talk about, okay, state law resolving contracts issues, and not federal law. Or federal laws usually only come in particular circumstances to override usually state law, but that's unusual. So in your contracts class, you're generally going to be learning the rules of contract law that have been adopted by states, not by the federal government. It tends to be state related. The second big thing to keep in mind is the distinction between statutory law and the so-called common law. Steve, do you think it's fair to say that most incoming students and laypersons in general, when they think of the law, they're thinking of statutory law as opposed to common law?
Yeah, absolutely. I think that this is, and I'm so glad you're bringing this up, because there's a lot that we bring to law school, this perception that's in our own heads or in our own experiences. Maybe we have a parent who's a lawyer, maybe an uncle, aunt, somebody in the family's a lawyer. And we come to it with these ways of thinking, or these concepts that just maybe aren't true or aren't nuanced enough. And it's really a struggle in the beginning to kind of get our hands on the complexity of law. And so it's just back to the earlier point. I think it is important to really, really come in thinking, okay, I know nothing, kind of wipe the slate clean and say, I'm here to absorb what I'm learning in my first year contracts class, because we don't know what we don't know until we know it. And it's important to approach this as though we don't know what we're doing.
Oh, it's got to be a clean slate. I can't tell you how many times a student will say, even well into the semester, something like, well, you can't do this. Why not? I don't know. I mean, that's my understanding is you can't. The Google? Yeah. And I warn my students too, that when I try to guess, I get questions that I don't know the answer to, and this is some of the great things about the law, is that there's a lot of it. It's a bad thing and a great thing, that there's always new questions. You'll never master any area. I mean, I'm still learning. I learn every semester. And I tell my students that when I don't know the answer, I will hazard a guess, but I warn them that more often than not, I feel like I'm wrong when I guess. It's not always, it's not intuitive. And so statutory law. So we have, not only do we have, you got to figure out what source of law, but we have two general different types of sources of law. We have statutory law, which is laws enacted by the legislature. So for example, the Florida legislature, the Nebraska legislature, on the federal level, the US Congress. And that's what probably most people think of is the law. But there's a little secret. It's not really much of a secret. There is law made by the courts. Now, I think, remember you used to have to take a civics class. I don't know if they teach civics anymore. Did you take civics, Steve?
Yeah, I think Florida requires it. I did, yes, but many states don't. So depending on where the students grew up, they may or may not have had a civics course.
Do you know how old I am? I took AVC. Do you remember a course called AVC?
No.
Can you guess what AVC stands for?
No clue.
Americanism versus communism.
Wow.
That's old I am.
That's old school right there.
That is old school. So when in civics or whatever you take now, American government, whatever, you're taught that the legislature makes the laws, the executive branch enforces the laws, and the legislative branch interprets the laws. But the truth is that in the US and some other countries, England notable, and the former English colonies, courts also make law. If a statute adopted by the legislature has not addressed a particular issue and a dispute comes before the court and there's no statutory law on the issue, the courts actually create a rule of law. Now, they look at precedent from prior case decisions as to what that rule of law is, but it is court developed. And we call this the common law. So the two main sources of law are going to be, in contracts anyway, are going to be statutory law and the common law. We don't deal that much with other sources like administrative law or constitutional law. Generally, it's statutory or the common law. And see, I was reading an article recently where the professor believed that the reason students often struggle initially in law school is that one's layperson mindset is actually what we call is a civil law approach. A civil law, as opposed to the common law, is where you have a code that is intended to cover everything. And courts don't make law. They must find the answer in the code. And the code is designed to be completely sufficient. And students, the problem is a lot of students don't realize that we have a common law system. They've heard that, but they don't understand the common law system means courts are creating law, and every case that's decided could have a slight change in the rule of law. It can move, and they're not just simply looking at a code. And we'll talk more about statutory and common law in just a second. And so, as Steve has already mentioned, or at least alluded to, the reason why it's so important to first talk about right at the outset of, say, an analysis of a contracts issue, what the source of law is because the sources of law could have different rules. And if you've got the wrong source of law and the rule happens to be different, you are providing bad information. And so that's why it is so important right at the outset to know what source of law is applying. Okay. We're going to, in contracts law, there's going to be two primary sources of law. So the statutory law that you're going to see in contracts is primarily going to be something called Article 2 of the Uniform Commercial Code. Now, Steve, you sort of got your wish, because I think you said at the beginning of law school, why can't there just be a single source of law that we go to? Why do we have to have multiple sources of law? We almost had a single source of law, but we stopped short. So an organization is actually two organizations, but who cares? A couple of organizations drafted something called a uniform law. And this organization that was drafting this uniform law was drafting, they didn't have rulemaking authority. They were not a Congress, they weren't a legislature. They were just a bunch of smart people. They were, judges, lawyers, law professors, and they got together and they created a code. Sounds very civil law-ish, if you think about it. We're kind of civil law-ish over here too. We kind of like codes too at times. Created a code for commercial transactions, for commercial law. The theory was that since so much commercial law was interstate transactions, it would make sense if all of the legislatures in the US had the same rules of law for commercial transactions. So that way, the wheat farmer in Nebraska, there's wheat in Nebraska, isn't there? There should be.
You got me.
Okay, all right. Well, what are you good for? Come on. So the wheat farmer in Nebraska and the buyer in South Carolina, don't have to spend a lot of time worrying about what the rules of law are and figuring ways at Nebraska, is it South Carolina? Are they different? It's a uniform set of rules for commercial transactions. And the code that resulted was drafted in the 1940s and 1950s, but again, who cares about that, was something called the Uniform Commercial Code. Everyone calls it the UCC. And it had a bunch of articles dealing with different areas of commercial law. The one you're going to spend the most time with in contracts is Article 2, because Article 2 deals in transactions in goods, sales of goods. So contracts for the sale of goods are going to be governed by Article 2 of the UCC. And the UCC, now, as I mentioned, these organizations that drafted Article 2, the whole UCC, they did not have lawmaking authority. Their hope was that state legislatures would adopt them. They were very, very successful. Steve, 49 out of 50, that's not bad. 49 out of 50 states adopted Article 2 of the UCC. Can you, so I'm gonna put you on the spot. Can you guess which jurisdiction did not adopt Article 2?
Yeah, I'm guessing that it would have to be a state that doesn't use English common law as heavily as the other 49. I think they use what the Code of Hammurabi in
No, maybe the Napoleonic Code, maybe, right? So
yeah, right. There you go.
are you thinking of Louisiana?
I am.
You got it. Yeah, that's almost always the answer, right? Every 49 out of 50 states do this. Almost always, I think the one that's out is Louisiana. So now, like, people who are in Louisiana watching this video are like, really? I wasted like the first 15 minutes and now I'm out. So
well, it's kind of cheating because they don't give the MBE, and the MBE is part of the bar exam, and that's the only jurisdiction in the United States that does not give the MBE. So that's kind of how I knew, because contracts Article 2 is tested on in the other 49 jurisdictions. So
yeah,
that got to that answer.
Yeah, you're right. So, yeah, so Louisiana had that strong French influence, and French law, they are a civil law jurisdiction. They have the Napoleonic Code, very successful code, but that's a different podcast, if ever. We follow the common law. So 49 out of 50 states adopted Article 2 of the UCC. And once they adopted it, so once the Idaho legislature adopts Article 2, voila, it is now law. It is statutory law. It went from a hope to actually becoming law. And so what that means is that when Article 2 of the UCC applies to a contract, so you're not, Louisiana law is not applying, you're anywhere else, then that means that the court must follow Article 2. The common law is out. You've got to follow Article 2, because if the legislature adopts a statute, that controls over judge-made law. The common law, remember, is only being used and being created in the absence of statutory law. So the first thing you want to look for probably on a contracts question is, okay, is this a contract where Article 2 of the UCC is going to apply? And if not, then I know to apply the common law. So let's talk about when Article 2 of the UCC will apply. Steve, I hate this. I just hate this. Okay. Article 2. This is supposed to be a code. Steve, codes are supposed to make things clear, right? If we're going to draft a code, we should make it clear. Fair?
You know, the more I learn about drafting, the harder it is.
That's fair enough. You're defending the drafters. Okay, that's fair. I've never drafted a code. You might be right. Okay, but here's the first thing that's a little bit tricky with Article 2, which I think in your contracts classes, you're probably not going to want to worry about. I don't ask my students to worry about it. Article 2 says that it applies to, quote, transactions in goods. That's the phrase, transactions in goods. Now, here's the problem, is that transactions in goods could be construed as more broad than a contract for the sale of goods. You might have a transaction involving goods where they're not being sold. For example, a bailment. I know most of you are like, what's a bailment? A bailment's when possession is given possession of goods is given to somebody. So, you know, you loan somebody something, they're borrowing it, and they have lawful possession of it, but they're not buying it. Well, that could theoretically be considered a transaction in goods because goods are involved, but they're not being sold. And early on, confusion resulted as to whether or not Article 2 should apply beyond just contracts where the goods are actually being sold between the parties. Should it be broader, applying to things like bailments or leases of goods? Unless your professor is going to harp on this, I would probably not worry too much about that in a contract class, as opposed to say an upper level commercial law class. We have more time to get into this if the topic becomes more important. I would just worry about, okay, is this a contract where goods are being sold from party A to party B? Steve, is this for bar prep? Is that the route you go? I mean, do you even talk about, quote, transactions and goods and whether it's broader than sale of goods?
Yeah, no, I teach, because I teach a course for the Florida bar exam on writing. And my rule that I give is that UCC Article 2 applies to sales of movable goods. One line definition, and that's a keep it simple, because the bar is a little more basic, more simple. Your contracts professor is going to expect you to be extremely precise. And Dan is alluding to something that I think is very, very important to mention, which is get to know the way your prof teaches the course, because we have a way we do things, we say things in terms of your generic run-of-the-mill contracts course, but each contracts professor does have their own little quirk and their own little passion. And if they go into bailments or something, then you'd better get over there.
That's right. Very good advice. Very good advice. But you know what's interesting too is Article 2, it says 2-101. That's the first section of Article 2. It says short title. The title is short title. This article shall be known and may be cited as Uniform Commercial Code -sales. Isn't that interesting? So it applies technically, if you really want to state it precisely, it applies to, quote, transactions in goods. Maybe not a bad thing, your first sentence, right? Article 2 on your exam. Article 2 applies to, quote, transactions in goods. But unless, as Steve mentioned, unless your professor is really harping on the fact that transactions goods might arguably be broader than sale of goods, for our purposes going forward, and probably for purpose of your class, you probably just want to think about it as, okay, Article 2 applies to contracts for the sale of goods. So the main issue there is not really what's a sale. I mean, we could talk about that. I mean, a sale is simply transferring ownership for a price. The only thing that I think is particularly noteworthy, perhaps, on that definition is that a sale includes a purchase for things other than just money. So if I'm selling you a tractor and you're transferring to me, say, a parcel of land, that's still considered a sale of goods. It's still a sale of goods, even though money is not being used to purchase it. Something else is. It could be a service. I'll give you this tractor if you mow my lawn for a year. That's a sale of goods. But that usually doesn't come up that much. It's usually money. The main thing I think here is to understand what goods are. What is the definition of goods? And Article 2 does give us a definition. It's things that are movable. And this is not a quote from the statute. It's a summary, but things that are movable, but not money. So, all right. So Steve, why don't you throw something out to me and I'll tell you if it's goods. Anything at all. Anything.
A power generator.
Power. Now that sounds really heavy. I don't know a lot about power generators. It sounds heavy. It sounds like I couldn't move it. So Steve, what do you think? If I can't move it, do you think that makes it not movable?
No, I bet not. And that's what's so funny about this. I'm thinking about goods that are movable. I'm trying to imagine goods that aren't movable.
By its very purpose, almost by its very name, goods are moved. Yes. And Steve, you're absolutely right. The fact that goods might be difficult to move doesn't mean they are not movable. Now, I'm going to throw a wrinkle in here. In the commentary, the comments to Article 2, Article 2, as it has these comments, they're very useful. I always thought comments are funny because they're kind of like admitting like, well, the code itself isn't very clear on this, so let's now explain it. It's a little commentary on it. And what it says is movable are things that may fairly be considered to be movable or something like that. So you could get to things that are attached to land, permanently attached to land, like a house. Okay, so unless you're a mobile home, a house, that's not fairly considered movable. So you don't want to get too weird about this and be like, well, law students sometimes do this, right? And sometimes it's good and sometimes it's not. And it's a hard time figuring out as a student, when is it good to do this and when is it not? Well, a house is technically movable. I've seen houses going down the street, right? Wide, low, they're carrying an actual, I don't mean a mobile home.
Wizard of Oz, wasn't it? Didn't the house just plop down on the witch?
Hurricane comes. Yes. I mean, how does it plop down on the witch? Is she considered that thing movable? But I think the point is she was surprised it was moving. Don't you think?
I think so. I think so. That was a big thing to have dropped on her.
So that's right. So this is, though I guess I'd be surprised to see a generator going through the air. So things are movable if they are fairly considered movable. So if they're considered, let's say, permanently attached to land, which when we say permanently attached, we don't really mean like forever, but basically meaning it's like a fixture. It'd be really hard to like uproot it. But if it's movable and it's not sort of attached to the land, even though it might be difficult to move, like a generator, like Steve said, and I know nothing about power generators, but I'm imagining something big and heavy, then that would, and assuming it's not been like, don't make things hard on our first episode, assuming it hasn't been like really like massively affixed to the land. Like I'm selling you a power generator. Power generators are us. That's goods. It doesn't matter that it's really heavy. It's movable. And so, yes, that would be goods. You got anything else for me?
Well, yeah, on that topic, and the reason I threw out power generators because it was something that kind of blurred the lines to me, something that could be affixed to the land semi-permanently. And let's say we go back to wheat clearly movable, right? Would that be what you say?
Okay, we're probably getting more in depth than our poor first year contracts, episode 1 lawsuits would want us to be. So there is a section in the code on things growing on land or on land and things under land, like minerals and above wheat. And there's actually a special rule for that kind of stuff. So there's no doubt that wheat is movable. But the question, strangely, is if I'm selling you wheat, the question is growing wheat, growing crops, not wheat that's in, I don't know, what is it? Is it like an elevator? Is it a grain elevator? That's grain, right? A silo, I don't know, a barn, something.
You're so right. I did not mean to make it complicated because I was thinking, and this is so funny when we're talking about what perceptions we bring to law school. And I'm imagining just wheat that here you go, $5,
right,
and just exchange it. And that's clearly a movable good. But you're right. There's this whole thing about growing wheat and is it fructus naturalis and whatever. I'm not going there, but it's funny because I just did what I said, be careful to do.
No, but this is great because this is what students, and this is what students will do. And it's understandable because their minds are popping. They are starting, they're being trained to be lawyers, and you're trained to think about, well, is the wheat growing? Is it been severed? These are all very important questions when you are practicing attorney. And these questions will probably, the further you go into law school, these kind of details get brought out more and more. But to back up, so when you said wheat, is it movable? You said you envisioned, hey, I got some wheat. I got a farmer's market. I don't know, you sell wheat at a farmer's market. I got wheat. And here it is. Here's my wheat. I'm not standing in front of a field. Yes, that's movable. So yeah, wheat, absolutely. Harvested crops, absolutely. It's movable. That would be goods. Interestingly enough, so I don't know, we thought some other examples. You know what, a desk, a pen,
a car,
painting behind me, all goods, all things are good. So maybe it's easier to talk about things that aren't goods, but I think we have a slide on that. So why don't we pause there? So goods are all things that are movable. Now, movable, keep in mind, I notice what you've been saying, Steve. You've been saying movable goods. That phrase is a very common phrase. You are in good company. Judges will use that phrase. I see it all the time. So I have a mild issue with the phrase movable goods. You know why?
Why?
you said it like
I'm unmoved. I'm unmoved.
You're moved. You sounded like you were in trouble. So the definition of goods are things that are movable. So movable goods.
Yeah, so it's like an ATM machine.
Oh, you're right.
Teller
Automatic.
machine.
Exactly right. Movable goods. And so movable goods are movable things that are movable. So
Yeah.
in my class, you could just say goods, but everyone sort of says movable goods. I don't think I don't think your professor is going to have a big issue
I think
with it.
lawyers, that's how you can tell a lawyer is serious, is when they start repeating themselves.
That's probably true. That's probably true. We say things multiple times.
Yeah.
Okay. So money. Yeah, this is a little tricky. Money can be goods and it might not be goods. It depends upon how it's being used in the transaction. So if money is being used as the price to buy something, and simply that, it's just you're using like how much money for this, it's not considered goods. This is probably not so, students are probably okay with that now, because how many students are breaking out the change or the dollar bills nowadays, right? I mean, students, have they seen money like that?
Yeah, I don't know, especially if you just sort of came into your own during the pandemic, you'd never see a dollar bill.
Right. And who don't, right. And who don't want to touch that thing now, right? So the money that is used to purchase is not considered goods. So for example, a loan contract, there are no goods involved there. It's money for money, right? I mean, if a loan is money for money, money now for money later. And that money is just the price for the other money. So it's not good. So a loan contract, it's not going to be Article 2 of the UCC. There's no goods involved. I said a loan. I'm trying to think. Oh, insurance is what I was saying. An insurance contract, that is also money for money. You may never get the money because your house may never burn down. But so an insurance contract, no goods involved there. When money is goods is when the money is being sold, as we say, or the code says, as a commodity, meaning a rare coin. So I have a buffalo head nickel and I sell you that for $20. The $20 is not goods, but now all of a sudden the buffalo head nickel is goods because it is being sold as a commodity. Another thing to keep in mind with Article 2, which I think students often get confused about, is a lot of students believe that you have to have at least one of the parties be a so-called merchant in order for Article 2 of the UCC to apply. Steve, do you see that even 2 years after they've taken contracts and they've taken commercial law, they're studying for the bar? Have you seen this confusion with students saying, oh, Article 2 doesn't apply here because there's not a merchant, or it does because there is?
Yes, and I'll tell you why I think we see that is because students before law school, they're not used to drawing hard line distinctions between things. They learn a bunch of things and then they spit it out and it's okay. And they got credit for it in the past. And now they're struggling to make hard line distinctions where this ends and that begins is all lawyers deal with. And so they're not used to that hard line distinction and keeping things separate, keep this separate from that. They blend it all together because they haven't learned to, master a topic. They haven't learned to digest it to the specificity. Billions of dollars are at stake with one word being this word versus that word. Not used to that. And so when it comes time to merchant and non-merchant and what applies with merchants and what doesn't, it all just sort of mixes into mush in the student's mind. And I know because that was what happened to me.
I'll never forget, I had a student when you said, Professor, your multiple choice questions are very tricky. And I said, that's the law. Yes, correct. It's what you said earlier. This is why you're going to get a job as a lawyer. You should be happy it's tricky. Of course it's tricky. My questions aren't tricky. I'm just asking you about the law. The law, I basically was trying to blame it on the law. That's not me. It's the law.
Yeah. Right. And I think that there's something I think I've said to you in the past where I think the questions don't trick people. Students trick themselves. And they trick themselves by not drawing these distinctions and keeping things separate and testing themselves. And, I think that's the tough part of this, is that you have to prepare for this unlike anything else. But yes, the whole merchant thing, and then they blend, we'll get to it, but the statute of frauds, the $500 thing, that thing gets mixed up. And if you just keep your rules separate, keep everything different. And so this whole no merchant or minimum price requirement to apply the Uniform Commercial Code, when does it apply? When does it not? Keep that separate from anything else you learn in contracts.
I can't tell you how many times I say to students, okay, well, that's relevant to something else that we'll be talking about, like you mentioned, statute of frauds, in a month or so. Just don't worry about that now. I agree with you 100%. Keep things compartmentalized. And for source of law, all you're worrying about at this point in time is, does Article 2 of the UCC apply, or does the common law apply? If you see other issues floating around that are related, just hit the pause button. Deal with that down the road. Don't let it all become mush like Steve's talking about and start infecting the analysis that you're giving. Go step by step. So all we care about now is we're checking a box, right? You talked about decision tree, Steve. Which road are we taking? Article 2, the UCC, or the common law? And we're going to talk in a little bit about when I think maybe you might want to perhaps bounce a little bit back and forth. I think you gave some great advice about you don't want to bounce around a lot, but we'll talk in a bit about maybe sometimes where a professional like myself might like you to maybe bounce a little bit. But this first question is just Article 2 of the UCC or the common law. And the whether one or none or two of the parties happens to be a merchant is irrelevant to whether Article 2 or the common law applies. It is a big strike through. So the question becomes, why am I mentioning something? Why am I planting a seed, perhaps in students' minds, to think about something that they weren't even thinking about? Why are you telling me not to worry about this? Now I'm going to think about it. You have to be a merchant? Why? What?
Is it because you always get this on your final exams?
Yes, of course. It's because what's going to happen is Article 2 of the UCC has certain rules where the standard of care, that's not a great phrase, right? But the standard is higher for a merchant. Merchants are held to higher standards. So, and when we do more podcasts, again, if we're picked up, when we do more podcasts, you're going to see some UCC rules. So look, so what you're going to see is, number one, you first got to figure out if Article 2, the UCC, applies to the common law, because the rules are sometimes different. Then what you're going to see, if you do say, okay, well, it's Article 2, you're going to find that even some of the UCC rules themselves branch off and have different standards as to whether a party is a merchant or not a merchant, because we want to hold business people to a higher standard than just your typical consumer. And so what happens is that when students then start studying those rules where merchants are held to a higher standard, I think they kind of backtrack and they then allow that to bleed into this issue and they bring it back, and it doesn't belong. I mean, so what are you doing? Hey, I'm a merchant. I don't care. I'm on a source of law. I don't care that you're.
And that's the worst time to do it, because that's usually the beginning of your essay. So you're just saying, hey, prof, I didn't prep for this adequately, and I don't know what I'm talking about, right at the beginning.
So what some students will do, which is not terrible, and I think this is sometimes advised in bar prep. I don't necessarily mean your bar prep program, what you're doing, and this is not a massive problem, is I know sometimes students are told that it's not a bad idea that if a party is a merchant, to identify that a party is a merchant, but then you better say that means that they may be held to higher standards or some of the rules. So it's okay, I guess, to mention that at the outset, but please don't in any way lead your professor to believe that you are saying that merchant status somehow dictates whether Article 2 or the UCC applies. I mean, I'm not a big fan of this, because I'm with you, Steve. I like compartmentalized discussion. So that first source of law paragraph, I kind of want that just to be about source of. I'm the kind of guy, I don't want my peas over near my potatoes. I actually like those plates that I used to get for my daughter that have, the little barriers little walls on them, the ridges.
Oh, right, right.
Right. And so I don't want anything infecting that nice little pure source of law discussion. And I think another reason why students think that merchant, or maybe think that merchant status is relevant to source of law, is that Article 2 deals with transactions and goods. It's a commercial law code. It just sort of oozes merchants, doesn't it? It's like, this is for, it almost like saying, this is for merchants, but resist. So so Steve, if I was selling you a baseball card, and I don't know if we have baseball cards anymore, if I was selling you a baseball card, and I'm not a dealer, like I'm a professor in contract law, I'm not a baseball card dealer, so I just happen to have a baseball card, and I'm selling it to Steve, and Steve is not a collector. He just happens to want this particular baseball card. I don't know, it's his uncle or something. That transaction would be governed by Article 2 of the UCC, because we know that a baseball card is goods. It's movable. And it doesn't matter that I'm not a dealer in baseball cards. It doesn't matter that Steve is not a dealer in baseball cards. Article 2, this is what we call a casual sale. Article 2 is going to apply to that. And also, importantly, it applies even if the sale price. So Steve, let's say, give me a sales price. Give me a low sales price for the sale of that coffee stained, bent baseball card of your uncle. How much am I selling that to you for?
$1.
$1. That is a bargain. So $1. What do you think? Say Article 2, should it apply? Yes or no?
Yes. And and I'm gonna say it in a different way that maybe might resonate with somebody listening. Whether UCC or common law applies depends more on the subject matter of the contract than the people involved in the contract.
Or the price.
Or the price. It's the thing, it's the subject matter. And that is what is critical. Wait, am I right on that?
You got it. It's all about the baseball card, is it not?
Yeah, that's right. That's the rule, right? It's transactions and goods, sale of goods. Is it a good? The question is about the subject matter, not the people, not the price, not anything else that you learn after that rule.
And I know baseball cards are movable because we used to put them on the spokes of our tires on our bikes. Remember that?
Yes, that was the best. I don't know that anybody does that anymore.
They'd flap. Well, they were all doing those scooters or hovercrafts, I think. Now.
Yeah,
I think
they teach you how to put the cards and the spokes in your communism versus
American history. Yeah. American culture class. So yeah, so that's absolutely right. So it does not matter that it is a transaction between two non-merchants for a small price. It could be $1, it could be a penny. It could be not for money. Remember, it could be I'll give you this baseball card if you mow my lawn tomorrow. That's a contract for sale of goods. And yes, Article 2 of the UCC applies to the transaction. It may be like, wow, Article 2 cares about that. I mean, Article 2 seems like such a big deal. It applies to that transaction. And the reason why students get confused about this, and again, maybe I'm planting seeds seeds of confusion where I shouldn't be, is because there is something, but Steve started it. Steve alluded to something called the statute of frauds. Again, I'm just mentioning this now, so you don't worry about it now. The statute of frauds is a statute that requires certain contracts to be in evidence by a writing. They have to be in writing to be enforceable. And Article 2 says that if a contract for the sale of goods is priced $500 or more, not more than 500, well, yes, that too, but also 500 or more, it's got to be in a writing to be enforceable. And a lot of students, I think, when they learn that, they then maybe come back here to this session and somehow graft onto this source of law discussion a requirement that Article 2 is only going to apply if the contract has a sales price of $500 or more. That is false. And Steve,
that's the one that I see more than the merchant thing. But I think it's what we're saying. The same thing happens. We learn too much material and we let it bleed over, but that segmented learning and that keep this separate from that. And in fact, I think that's what students ought to do when they learn something. How is this separate from that. Because I think that the gut instinct that a student brings to this is, how is this like this? Oh, this reminds me of this other thing. But I would almost ask students to say, how is this different from the other thing? And that step may help somebody keep it separate.
I agree completely. I can't tell you how many times I say to students, when they bring up some topic, I'm like, wait, what are you doing in this room? So I like to think of subjects as rooms in a house. And the source of law is kind of like, I guess the source of law is what, the foyer? Is that fair to say? Or the porch, maybe? I don't know. Foyer. So you come in and, and if you're in the foyer and that's source of law, and someone's saying like, hey, I'm $500 or more. I'm like, who cares? What are you doing here? Or statute for what? You're in the wrong room. And so I agree with you completely. You want to keep these things separate. And then let me tell you something. Professors, when we sense student, this is going to sound horrible, Steve. I'm not even sure I should admit this. You probably know where I'm going with this.
I do.
You do. No, it's cruel. Yeah, you were there. You were there 1,000 years ago. So when we sense student confusion, here's a secret. We're kind of paid to sort of test you on things that you might be confused about. So think about if you're drafting a multiple choice question as a professor, and let's say the question is just about source of law, which you might get one or two of those, I don't know. And think about, we need 3 wrong answers. I mean, what's the wrong answer going to be? A desk isn't movable? I mean, come on. I mean, no one's saying that. It's going to be the desk is being sold for less than $500. Therefore, Article 2 doesn't apply. The desk is being sold by 2 non-merchants. Therefore, Article 2 doesn't apply. That's C and D, basically. Those are your distractors. These kind of things, I hate to say it, but it's a living. Student confusion is where professors oftentimes come up with the wrong answers. And the reality is, I mean, I joke about, it's that we're being evil doing that. We're really not, because if it's student confusion, these are the areas where you don't want to screw that up in practice. You don't want to be like, oh, wait a second, Article 2 doesn't apply because it's less than $500. I don't know why someone's suing over less than $500, but whatever. These are the things that you want to make sure that you don't screw up in practice. So yeah, no requirement of merchants. Get that out of your head in this discussion. And there is no minimum price requirement. Okay, Steve, anything before we move on to a more complex topic? The hybrid.
I was just going to amen what you just said and say that that's how the MBE is drafted. Exactly as you described. Those are the contract's distractors. And there's a reason that 3 years after these 1Ls, enter law school, that they're answering the same questions wrong, is if they, and this is the moral of the story, I think, is take practice questions. When you finish a topic, a discrete topic like choice of law, if you can find yourself a question or two on that topic, it wouldn't hurt to test yourself and try to draw those hard line distinctions. In fact, sometimes that's what helps you see it clearly, distinctly, is actually doing a question like that.
It probably become easy, I think. If once you know what the student confusion typically is, and you're on the lookout for it, it probably becomes. Of course, everything becomes easier once you know how to do it. I have a confession to make. I once missed one of my own multiple choice questions. I was like, wow, that's rough. I would have missed it. It only happened once, but I was doing the key. I did catch it. I was doing the key. And I'm like, wait, what? The first time through the key, I missed my own question. I'm like, wow, that guy's a jerk.
Boy, and I know a guy who totally got them all right.
Steve Maxwell is the last student of mine. This is gonna make you sound great and me sound horrible.
That's why I mention it.
Yes, thank you. I appreciate that. Steve Maxwell, and I think this was spring of 2009, was the last student to get all of the multiple choice questions in one of my contracts classes correct. So I'm waiting to give out the Maxwell Award again one day. Now there were some extenuating stories. So you didn't have a midterm, right?
That's right.
That's right. And it was,
but I was midterming myself. And that's what I would encourage students to do is don't wait, don't leave it to the professor to help you see these distinctions. Take it upon yourself. This is one area where in undergrad, you had to learn, the professor was there to teach you. Now in law school, I think you are your own best teacher in many respects. You've got to, because there's only so much a prof can do during class time in law school. You've got to take, a ton of time outside of class to take it upon yourself to teach yourself how to do this and do this well. And so that was my secret sauce.
Indeed. Practice, practice, practice. So hybrid contracts. So things are going to get a little bit more complicated here. So hybrid contracts, also called mixed contracts, are contracts where the transaction involves both the sale of goods and something other than the sale of goods, typically a service. Doesn't have to be a service. It could actually be the sale of land too, but they're typically service. So we'll probably use that as our sort of model of a hybrid contract. So for example, let's say that you are buying a refrigerator from an appliance seller and this is part of the same contract. So not two separate contracts, but part of the same contract. You also purchase delivery of an installation of that refrigerator. And so they bring it and they install it. Or maybe you call a plumber and the plumber is going to both come out there and figure out what the problem is and fix your pipe. And as part of fixing the pipe is also going to sell you the parts that are installed. We call these hybrid contracts because they involve both the sale of goods, but they also involve a service as well. And to give you an example of a hybrid contract where there's land, because it doesn't drive me crazy, but people always say, well, hybrid contracts involves both service and goods. That's true, but it could also be sale of a house. Let's say I sell you my house, not a mobile home. I'm fancy, okay? No mobile home free. Those days I did have a mobile home, but those days I've moved on. So my house is permanently attached, affixed to the land. So that's not goods. But let's say I sold you, Steve, all my furnishings, like that painting back there is included. That would be a mixed contract too, because it involves both the sale of land, which includes the house. None of that is goods, but it also includes the furnishings. And if that includes the painting, well, of course, that painting is movable. So you can actually have a hybrid contract when it's something other than services, but it's typically services. Okay.
Now, can I point out to students that are listening, please take note of when your professor does this. If they give examples, what they're doing is they're telling you how to spot this issue and where in a fact pattern, because your exam is going to be a fact pattern like this, that there's a situation where a mobile home and there's going to be furnishings and goods inside. And this is Professor O'Gorman, he's trying to tell you to spot the issue. And this is a skill that's hard to acquire. And he's just handing it to you here. So I want your ears to pick up. These are examples of fact patterns where you're going to have to argue this in an essay.
You're giving me more credit than I'm due, but this almost reminds me of a reaction video where like you're pausing me. You see what Professor O'Gorman just did right there? He's giving you this is a reaction video.
Well, it is kind of, I think that's appropriate here because like, I'm kind of that, we had that dynamic where you did old school Socratic with me and I had to kind of figure it out. And so I kind of have this, I'm a little low key jealous here that here you're now handing it to students. So it's kind of nice to see you come full circle
here. You're a little better.
Well, it took me years. Just
10 years. You're getting over a lot of stuff. Wow, that was a pretty traumatic class of mine. Okay, so hybrid contracts are going to present an issue because, wait for it. Article 2 doesn't tell us how to figure out the source of law when it is a hybrid contract. Don't get me started on my thoughts about Article 2. You're probably getting a sense of me and Article 2, but Article 2 doesn't tell us what to do. So courts were left to decide on their own. Courts have a code, but if the code's not answering the question, courts have to figure it out on their own. And so courts very early on had to figure out what to do with a so-called hybrid or mixed contract. What source of law How do we figure out what source of law applies? I mean, it's easy when it's a non-mixed contract. I'm selling you my moped. Okay, it's Article 2. I am going to mow your lawn for money. Common law, easy. Then we get the cases dealing with, say, delivery, or maybe you're designing something and then selling the final product. That's a mixed contract. Construction jobs, you're selling the materials because it's going into the house, but you're also building the house. And Article 2 didn't answer the question. So courts had to decide what to do. Now, courts could have done there's different choices here. What the courts could have done was said, we're going to apply Article 2 to any contract if there is any sale of goods involved at all, even if we think it's a minor portion of the mixed contract. This is sort of what was called the final product test. The final product test really dealt with situations where you're building stuff, you're designing something. I'll design a display case for you, and then I will give it to you, sell it to you. And so the final product is movable and goods. So courts could have said, anytime the final product is movable, it's goods. Now, note that's a little different. You could have, well, I'm selling you these goods and I'm going to deliver and install it. It's kind of separate goods and separate service. Or it could be the service creates the goods. Like, I'm going to create this display case or design it and build it and manufacture it and give it to you. Two different ways. Courts could have just said, well, we're going to apply Article 2 to all of those. Courts have not done this. That's out. So forget about it. Forget I even said final product test. Ignore it. Out. Another thing courts could have done is they could have said, well, you know what? We could apply Article 2 to the sale of goods portion and apply the common law to the non-sale of goods portion. Some courts, not many, actually adopted this approach. It's called the gravamen of the action test. This test, Steve, this test is on the run. This is like the final product test. Very few jurisdictions, if any, follow the gravamen of the action test. My guess, just a guess, is that for your first year contracts class, you can probably, again, check with your professor. Does he say gravamen of the action test? If you never hear about gravamen of the action test, you probably can probably ignore it in your first year contracts class. You might deal with it more in an upper level commercial law class or sales class. What the overwhelming majority of courts have decided to do, and this is the only rule I teach in my survey contracts class, is the so-called predominant purpose test, also called the predominant factor test. Either name is fine. And what this test is, and it was decided upon by most courts said, well, we're going to follow this rule. They just created it because Article 2 didn't tell them what to do. What this rule says, what this test says, is the court will decide whether the goods portion of the contract predominates or the non-sale of goods portion predominates. And whichever portion predominates will determine what the source of law is going to be. So let's do some easy examples, ones that I would call multiple choice questions. So Steve, when I say I consider this a multiple choice question, what I'm saying is I consider this to have a clear answer, maybe not easy, a clear answer. And when I say, well, that's an essay question, I say to students, well, that sounds like an essay question. It's debatable. So let me throw out to you what I at least consider to be some multiple choice predominant purpose questions. Construction job. Your typical construction job, someone's going to build a house on my land. And does that involve the sale of goods? Yeah, maybe. I mean, I really am not interested in spending a lot of time discussing whether they're ever goods or not, because they're going to be attached to the house, which is going onto the land. But let's say there's goods involved, because let's say you're selling me the shingles in some way, right? You're supplying the shingles and you're supplying the wood and the concrete, and that's all movable. It's all good. So I can't move it, but somebody can. It's fairly movable. So let's say a construction job is a hybrid contract because there's a service involved. They're building it. Your typical construction job, the predominant purpose is going to be considered by the courts to be the service of building. I mean, think about it. You're not really like, if you hired somebody to build a house, would you say, oh yeah, I'm buying a house from that guy? Like, oh yeah, where's the house? Well, they got to build it. Or would you say I'm hiring this guy to build me a house? I think you'd say you're hiring the guy to build you a house, wouldn't you?
Yeah, absolutely. I would.
And I think sometimes that's sort of just the way you would phrase it, like when you're describing the contract, can help. So your typical construction job is, I have that as a multiple choice question. Apply the common law. Now, that doesn't mean you can't have the general contractor, the guy who's building the house. He might have a contract with a supplier, so-called material man, to maybe supply the nails, and he's just buying the nails. Well, that would be Article 2. But the main construction job with the so-called landowner, that's going to be, yeah, maybe it's hybrid, but that's an easy hybrid one. The predominant purpose courts are pretty much almost always going to be, it's going to be the common law because the service portion predominates. The other multiple choice one that I think is easy, and an example under Article 2, are manufactured goods. So let's say that, a lot of books are print on demand now. I think my casebook, Steve, is print on demand. Shocking, isn't it?
It is.
It is shocking. You'd think they just have warehouses full of them, wouldn't you? No, I don't know. They may. They may.
Oh my God. I'd be hoarding them if they did.
Right. They may actually have inventory somewhere that they're trying to move. So, published by Carolina Academic Press. So a contract for manufactured goods. So let's say I order a book from Amazon, and Amazon's going to do print on demand. That's going to be Article 2. Yes, there is a service involved. They are printing it. They are binding it. But manufactured goods, the predominant purpose is going to be considered the sale of the book, not the bind. It's not like I'm like, man, I really wish I could find someone to bind this book. Who's good at binding? You want to buy the book. And it's just incidental that they are happen to be printing on demand and binding it. And here's something that's a little more interesting. Specially manufactured goods. Okay. Article 2 of the UCC has a definition for goods, things that are movable. And in parentheses in that definition, it says including specially manufactured goods. I think this is an important point. This specially manufactured goods business is sort of welcome to law school, welcome to thinking like a lawyer. So the fact that goods include specially manufactured goods does not necessarily mean that Article 2 always applies to a contract for the sale of specially manufactured goods. Now, students might be saying, what are you talking about? Article 2 says goods include specially manufactured goods. I get it. But if you think about it, every hybrid contract includes the sale of goods. That's what makes it hybrid. So the mere fact that a hybrid contract includes the sale of goods cannot necessarily mean that Article 2 automatically applies, because that was rejected, or that was at first test, that was rejected. So the mere fact that specially manufactured goods are defined as goods doesn't automatically mean that Article 2 applies. But
that kind of strikes me as being one of those, go back to the rule, go back to the predominant purpose. And if you stick to the rule, you're going to be okay. But if you let other things kind of permeate your thinking, you're in the wrong room.
If you're in the goods room, I now see like a bunch of like boxes or something, right? A lot of inventory. If you're in the goods room, like you go in there, like, I don't know, what am I? I don't know. Am I goods? Am I not goods? How do I find out? This is like a closet in the foyer. You come into the foyer, which is Article 2 versus common law. And I'm like, hey, okay, what are you? I don't know. Okay, go into that closet. That's the room for you. Then when you come out and tell me what you are. When you go in there, you're just trying to find out if you are, so you're like specially manufactured goods. You're like, I'm not sure if I'm goods or not, because I'm like specially manufactured. Okay, stop, just go in that closet. And you go in there. And the guy in there says, okay, tell me about you. Well, I'm specially manufactured. I'm a trophy that's being specially made for this spelling bee or whatever. And it's got a big B on it, and it was designed like a cake. You go to a grocery store to get a birthday cake for your kid, and it's, I don't know, it's got, Yodas and baby Yodas on it or something. I don't know. Do I have to pay a royalty now for that? So I'll edit that out. Okay. So it's got, Yodas on it or something. and which I probably won't do. And he said, well, I don't care that you're specially manufactured. Are you movable? Well, yeah, I'm movable. I'm a trophy. Of course I'm movable. Or I'm a cake. Of course I'm movable. Your goods. They write you a little note. Your goods. Or they stick a little sticker on you. I'm goods. They push you out of the closet. And now you're back in the foyer. And the foyer says, okay, tell me, so you're goods, but you're specially manufactured goods. Now we got to figure out, because you are hybrid still. Yes, you're goods, but there's a hybrid aspect to you, because the seller is both manufacturing, which is a service, and selling the goods. And so yes, especially manufactured goods contracts are hybrid contracts. Even though there are goods involved, there are always goods involved in a hybrid contract. The question now is, as Steve, you mentioned, is let's go back to fundamentals. Okay, we know there's goods involved. Big deal. What predominates? Okay, I'm going to make things a little bit tricky. You tell me if I've committed a foul here. I believe that the fact that Article 2 defines goods as including specially manufactured goods is a signal, is the drafters of Article 2 whispering something. And you know what they're whispering? They're saying, we believe, I probably shouldn't whisper on a podcast, pretend I'm whispering. We believe that most specially manufactured goods contracts should be governed by Article 2. Do you buy that? I'm not saying you don't have to buy that, Steve. I mean, if you're my student, you would probably want to buy it. You gonna buy that?
I am going to buy that. I think that sounds good to me, in the sense that they anticipated courts and litigants saying, oh, but this is custom. This is more about the service. This isn't the same cake that they just sell in the display cabinet. I performed extra services to make this particular to you. And so I'm going to try to argue it out of the UCC and into the common law. I think that the drafters anticipated that argument.
I think well, obviously I agree with that. I think that's right. And I think it was very well put by you. I think that's right. I see that as sort of a signal that just what you said, that they see people trying to make this argument that, well, wait a second, if they're manufacturing, this really isn't a transaction in goods contract. And they're basically saying, stop, no, we think these still should apply. And that sort of makes sense, because Article 2 was built for contracts for the sale of goods. And you know, if you excluded specially manufactured goods contracts, it seems to me you would be chopping out of Article 2 a large portion of sale of goods contracts. And so here's the thing that's a little tricky, is I think that it is a signal that your typical, it's going to sound weird, I don't know if this is redundant, your typical specially manufactured goods contract is the predominant purpose is going to be considered the sale of goods. And that was a signal from the drafters of Article 2. Yet it is still a hybrid contract. Thus, in some situations, the specially manufactured part may be so special that it actually predominates over the sale of goods part. And so it's not dispositive. And that's probably a word incoming law students should get used to know. Dispositive, right? The word dispositive means it disposes of the issue in and of itself. It's automatic. When you see X, you know the answer then is Y. I don't think the fact that it's specially manufactured goods means it's dispositive that it's Article 2. I think it goes a long way towards saying almost that's like a presumption that it's going to be Article 2, unless there's something really significant about the specially manufactured part to override it. Is that you are you buying this, Steve?
I am, because the factors are still the factors. And if the customization is such that the cost of the customization far exceeds the standard good, and the specially manufactured is now, 3 times what a standard good would be. If the customized cake is now $50 and the standard cake was $10, I think maybe now but that's back to earlier, you go with the factors, you go back to the basics. What is our rule? Well, we're looking here for a hybrid contract. Do we have one with the baking of the customized cake? Well, we do. but we apply the predominant purpose test and we go to the factors. And one of the factors is the cost of the goods. And if we see that the customization is so disproportionate to a normal good, then I think you have a really good essay on your hands there.
And let's, and you've brought up the factors. So this is an excellent segue to the factors. And before we get into the factors, I do want to mention, I believe that in the past, on the Florida bar exam, at least, was there not a question, a contrast question dealing with, was it the baking of cupcakes or something for a birthday party?
Yeah, it was cakes and pies. I think it was about 2005. And it was and I give this essay actually in my Florida bar topics course. And I get students all over the map on it, but it is a young woman who bakes cakes and pies, and she's been contracted to bake cakes and pies for a party, and also I think party favors and things like that too. So there's a mix. They threw in the baking, they threw at the pies, and then the party favors. And really, it's just an issue spotter, at least in my mind, because there's not a lot of facts in it. But it was hoping that you would bring up this mixed contracts case, this issue, and just argue it. But I think at the end of the day, are we talking about cakes and pies, or are we talking about baking?
I think that's right. And the good news is, I think this is good news, is that we are provided with some factors. Courts have identified numerous factors. I teach just what I think are the big three factors, though other people may teach more. This is not an exhaustive list. And so factors are different from elements. And I think that's something that students might struggle with at first. And the reason why I like Source of Law as a first class session, it's my first class session, is because it does bring out the difference between factors and elements. So elements are things that you have to have in order for a claim or defense to succeed, and you have to have every one of them. So, if you're taking crim law, you may see the elements of, say, battery, and every one of those elements, let's say, I don't know, like negligence, right? It's either 4 or 5, depending on your professor. In torts, in order to state a claim for negligence, you have to establish either all 4 or 5 of those. If one's missing, you're out. It doesn't succeed. A shout out to Professor Rooks, professor at my law school, who described it once as a links in a chain, right? It's a chain, and elements are. And if you lose any link, the chain collapses. I know other people have described it as, say, a recipe in baking, where if you leave out one of the ingredients, your cake fails. Those are elements. Factors are things when you have a rule of law that is vague. It's not clear. It's not cut and dry. It's something like, what's the predominant purpose? Okay, well, that's vague. How do I figure out what the predominant purpose is? It's not like, are you 18 and have full capacity contract? Just show me your driver's license. Single fact carries the day. When you have vague rules, courts sometimes will adopt what are called factors to help guide the analysis, to point you in the right direction. I like to think of factors as things as weights on a scale, and you kind of put a few over here, and you see which ends up carrying the day. Though not, you could have one factor that is so significant in one case that it rides, the fact that factors 2, 3, and 4 over here are carrying the other way. So factors are sort of like facts and circumstances that help guide you in deciding which way the rule should go. How have I done, do you think, Steve, on factors? Do you have any additional advice on factors?
Yeah, I think you've done a masterful job. The only thing I would add with respect to factors is I let the facts help me spot the factors. In fact, the first 4 letters of factors are fact. And so when I'm memorizing and trying to memorize, like I'll memorize elements. You have to memorize those elements because it's the chain. If you're missing an element, the claim fails. With factors, I think it is important to know a couple of big factors, especially ones that your professor assigned you to read cases about these factors. I do think you should know those. But lots of times I'll spot the factor in the facts. The professor is given facts in the fact pattern that make me think of those factors. And I just let those facts tell me, what factor is that fact? and I kind of reverse engineer those factors if I'm a.
Oh, and you ready for this, Steve? Oh, and Steve, it looks like you have frozen for a second. Oh, can I hear you? You have frozen. I'm going to keep talking. Hopefully you will come back. And so I'm going to let people in on a little secret, which is that as a professor, I reverse engineer as well. I look at the factors and then I decide what facts to include. So, and it looks like you're back. So let's get the factors out here. So for me, the big three, and other professors might give more, but the ones that I focus on, and these come from the courts, is, and again, remember where we're at. We're at a hybrid contract and we're trying to figure out we're on an essay exam. We're trying to figure out what the predominant purpose is of this contract, figure out the source of law. You're not here if it's not a hybrid contract. If it is a sale of just a moped and that's it, and there's no service involved, or no one's selling land to, you're not here. You're only here in the predominant purpose test if it is a hybrid contract. And I'll tell you, Steve, this is sort of one of my pet peeves, is that there'll be a straight up service or a straight up sale of goods. It's not hybrid at all. And students will be launching into a discussion of hybrid contract. I'm like, why are you talking about the predominant purpose test? Why are you talking about a hybrid contract? This is not a hybrid, move on. This is not a hybrid contract.
With that, and that's, I think, students who have trouble issue spotting. They have not been keeping track of how is this fact pattern different from this fact pattern. I think that's what students need to do, is how is the moped different from the cakes and the pies? And that step is so critical for students to keep those separate. But you're right. I'm so glad you bring us back to where are we? And I think that's the step that students don't take. They don't say, where am I in the law? Am I in this room or am I in that room? And if they do that more and more, they'll have greater success. Absolutely.
Oh, I do that all the time. I tell students it's like looking at one of those maps when you're at the zoo or somewhere, it says you are here. A student will say something like, well, the defendant should win because the plaintiff lied. And I'm like, where are we? Where are you? What element? What are you talking? I mean, I don't think anything is relevant in my class unless it is relevant to some element or factor or rule. Just saying some fact, throwing a fact out there. Hey, he lied. He should lose because he lied. Okay. Why? Well, because he lied. No, what? What factor? What element? Where are we?
And I think that's so different from undergrad school. I think in undergrad, I think that they're used to that being okay. And it's a very strange experience here in a law class, thinking, wait a minute, I'm wrong. That's totally BS. My attempt to create new law in the middle of class is not well taken. What?
It's not well taken. And we're not trying to bust your chops about it. We're trying to train you to understand that if you were in a court and you're like, well, my client should win because he lied. The next question from the judge is going to be, okay, why? What rule? What's the law? Facts have to be connected to law. They're not free floating, either one of them. They're always connected. And that's what we're doing. And so factors can help bring you, right? When you say, well, this is his business. Article 2 should apply because he's in the business of selling trophies. That's what he does. And I said, well, where are we? Why? Why is that a relevant fact? You could come back and say, well, professor, because one of the factors involved in deciding predominant purpose is the nature of the supplier's business. So a lot of times we're pressing you just to make sure that you know where you are. And you always want to, as a lawyer, you want to learn to explain. You want to say things like, well, my client should win, or Article 2 should apply because one of the factors is this, and the fact suggests this factor goes my way. A lot of what you're learning as a law student is explaining. I think lawyers in general are very good at explaining. Maybe they explain too much. but they're very good at explaining things, starting at the bottom and going up. And so we've got some factors, and the three factors that I teach, and they come from the course, as I mentioned, are the contract's language, second, the nature of the supplier's business, and third, the cost of the goods. And Steve, I just mentioned how I reverse engineer, just like you did as a student, you're reverse engineering on the exams. I reverse engineer as a law professor. So if I'm going to have a hybrid contract, let's say, I'm probably going to then look at the factors. And when I draft the facts, there's a reason why it's all working beautifully, Steve. When you're taking that exam and you're letting the facts lead you to factors, it's because I've been leaving crumbs or Easter eggs. I know you're walking down this path, and I know what will lead you to the left, to the right. And I'm going to drop some contract language in the facts, because I know, Steve, you're going to come wandering, hopefully, you're going to come wandering down the source of law road. You wouldn't want to like go through a upstairs window. You're going to come in the foyer. And I know you're coming, and I'm going to leave you some Easter eggs, some little crumbs. And so I will draft facts that will lead to these factors to be in play. And so remember, as factors, some may be in play, some may not. Some may be more important and more strong in that particular case than others. The first one is the contract's language. Now, I think this is interesting. I used to hate this factor, Steve. I'll tell you, I used to hate this factor. I'm like, really? The contract's language? Parties don't know what they're talking about. They just write contracts. They're not thinking Article 2, common law. Really? What the parties, how they sloppily draft their contracts is going to be relevant to whether we think Article 2, the sale of goods predominance, or the common law? I've come around to it. I've come around to it. This is what happens when you teach for years. I've come around.
It can grow on you.
It has grown. This factor has grown on me, Steve. I don't hate it anymore. It's kind of grown on me. I think there's something to this. The courts are smarter than I think. So I think that the way parties phrase the transaction is sort of a little window, not to the soul, but to how they view the transaction. And so language that you're looking for. I love this. Steve, I will put, if you see me put the title of a contract, like what's at the, a lot of contracts are titled, right? They have a title at the top. And if I put a title, I'm probably putting that title in there because it's a hybrid contract. I mean, why else am I putting a title? Because it's a hybrid contract. And I'm giving you a little clue. This is factor number one. And an example, Steve, so a contract, a title, can you think of a title that would shout that the sales portion of this contract predominates?
Contract for cakes and pies.
Okay, very good, right? Because you've got, so the contract as opposed to contract for baking, right? So
right, if it's contract for baking, then it would sort of go the other way toward the service. I really want the baking. I don't want the cakes and the pies.
And I like how you said it tilts the other way or whatever, because what you're avoiding, because you knew, I saw the wheels turning. When you were phrasing that, you were remembering that you were in the land of factors, not the land of elements. You didn't want to say, well, that means the title says it's a contract for pies and cakes. Therefore, it must be a contract where sale of goods predominates, because that would be an error because we're dealing with factors. Now, the scale is things are leaning, right? The sale of goods is definitely dropping down, right? Which I think on a scale would mean we're heading that direction, right? Down, yes, not up, right? Down. Say Article 2 is going down because it's got a lot of cakes and pies on it. It's got weight to it. And so look at the way the transaction is described in the title, for example. Don't just dive into the document itself, though you wouldn't be given the whole contract. Probably wouldn't be on your exam. Too much to read. But look at the title. I was thinking of something. Steve, I can be even more obvious on my exams, but sometimes students will still miss this, unfortunately. You know how obvious I can be? I can actually call that contract sales contract.
Oh my gosh. That's obvious. That's in your face.
That pie is in your face. So look for the title. if it says sales contract or contract for, and it identifies the goods like Steve was mentioning, this is definitely tilting in favor of predominant purpose being sale of goods. If it is, it could be service contract. I mean, we've probably seen contracts that say that, right? It could be contract and identify the service, contract for building, contract for baking. It's tilting toward service predominating, or it could be as obvious as service contract. Another thing to is in the language of the contract, the way the parties are identified. If the party, I know this sounds weird. See, this is why you should not be a big fan of this. I'm like, really? This seems kind of weird, but I don't know. It's grown on me. But who cares what I think? Because this is what courts are doing. I just report out. I don't make the law, I just report out. So if the contract defines the parties as buyer and seller, this actually tilts in favor of sale of goods. Now, people should know, students should know that contracts often do define parties. So Daniel O'Gorman, open paren, here and after, or whatever that old legalese, here that your legal research writing for us to tell you never to use, here and after seller enters into this contract with Stephen Maxwell, here and after referred to as buyer. Those definitions are evidence or way in favor of the court saying the predominant purpose is sale of goods. When it is, say, contractor, Daniel Gorman here and after contractor tends to push in favor of service predominating. And I thought it was kind of, I'm not in love with this factor, or at least with buyer and seller, because you can be a buyer of services, but I know people don't view it that way, right? They don't view persons as a seller of services. You are, like your employment contract. I know you're unemployed right now, so this wouldn't apply to you, but I know you're between jobs, but at some point, right, you will be a seller. I know it sounds strange to call you a seller, but you will be a seller of your services, and Miami School of Law will be a buyer of your services. But I think when people hear buyer and seller, they think goods. And so I think that the idea is that when parties define themselves as a buyer and seller in a hybrid contract, they're envisioning this as predominantly for the sale and purchase of goods, not the other part.
And you are undermining my not memorizing the factors approach by giving really great examples of professor attempts to include facts that go toward goods, go toward services. And you're kind of helping me envision a different approach where I'm looking at the facts, trying to see what facts I can use to push more good or more service arguments. Just anything in the facts that I can use to argue one way or another. That's what I'm looking for. Maybe I don't memorize all the factors, but I'm looking for anything in that fact pattern that can help me if I'm in the foyer. If I've got a hybrid contract here, I'm looking for absolutely anything I can twist one way or the other. And I am combing through every fact looking for that. And I think that's kind of the mentality that a student would need to approach something like this.
And let me tell you something, Steve, that's a separate room in the foyer. So the foyer's got like these secret passages and these secret doors. And so right there's the am I goods room where you're so clueless. You don't even know if any goods are involved at all. I mean, we could talk, that's like the growing wheat room, right? Growing wheat is going in that room. And so this is like a crawl space, like like below in the base. You open this trap door, a hybrid and it's dark and there's a lot of noise and it's a tough room, right? Because there's a lot.
Maybe we put the wheat in one room and the chaff in this other room
to separate the wheat from the chaff. Got it. Yes. So if you're in the hybrid contract is like a trap door in the foyer where you go in and it's like there's a lot. It's not a cut and dry room. There's a lot of shouting in there and arguing and debating. That's why hybrid contracts are good for essays. They're not good for multiple choice usually, because multiple choice, you need to know the source of law typically, unless you're asking about, how do you have a right answer typically? So typically for me anyway, multiple choice tend to be, they're not hybrid contracts. They're pretty clear. If they're hybrid, they're the obvious ones like construction or just manufactured goods. The nasty hybrid contracts, the ones where you'd actually start looking at the factors, like let's say a design contract where I'm designing for you something, a machine, and then I'm building it and selling it to you. That's nasty. That's you going down the trap door. You're in the foyer, but down below in the hybrid contract room trying to figure it out. And I agree completely with you, Steve. Look, as student, you want to be looking for anything. You don't need to be wedded to these three factors. I mean, you kind of want to remember them. Factors, they're there to help you. You may like hate them, like, really, more stuff to memorize? I hate this. Okay, chill. Factors is straight. They're meant to be light in darkness. They're meant to guide you on the right path. So for students that wouldn't necessarily think, oh, the contract says sales contract, I should write about that's relevant to our article when it's a hybrid contract. These are meant to guide you. And so for students that struggle with that, we're looking for a little more structure, a little more checklist-ish type students, I guess. Perhaps these factors and knowing these factors might guide them and have them stumble into what they otherwise would not have picked out. So contracts language, the nature of the supplier's business. What is the seller? See, they call him here a supplier. What is so if you're like a supplier, right, of human capital with I'm a supplier to Berry Law School. So what do they typically do? So does the seller typically, so think of the buying an appliance, a refrigerator from an appliance company. They're not a delivery company. You wouldn't call them up and be like, hey, I'd like to have you ship something. Well, is it an appliance? No. Okay, well, we don't do that. That's not what they do. It's an add-on. Their product business is selling the goods. You wouldn't, call up a delivery company, like, hey, delivery company, will you sell me this and deliver it? We'll ship it to you, but tell us where to go. We don't have any inventory. So it's what do they typically do? That is a factor. So I guess I like to think, like, let's say that a trophy company does some engraving if you want it, but they sell trophies. I mean, that's what they do. They're not an engraver. It's like, hey, I bring the ring to you. Will you engrave this ring for me? No, we do trophies. Their main thing is selling the trophies. So that would tilt in favor of sale of goods, even if you're having them engrave it. So that's factor number 2. So if you have a fact in your essay that says the seller generally sells this, or they generally do this, that's probably a little crumb there for you to use on your hybrid contract analysis. And lastly, or at least the ones that I give, the cost of the goods. This is probably to me the most relevant, but oftentimes we don't know the facts on this one. And this is how much does this goods portion cost and how much does the non-goods portion cost? And that's a pretty important factor, it seems to me, in identifying which the parties considered to predominate. But a lot of times parties do not separately identify a cost for one portion or the other. It could just be a bottom line. We'll sell you this and ship you this, and this is our price. And there's a bottom line. It's not itemized. And then you got nothing to do with that one unless you can kind of figure out what the market value would be. But if your essay answer identifies for you, well, the cost of the refrigerator is $900 and the delivery is $100, well, then obviously that pushes in favor. You want to mention that it is cost of goods would predominate. So, Steve, any thoughts, final thoughts on hybrid and mixed contracts and predominant purpose test before we move on?
Just a bit of advice for students listening that, in my experience, I see students avoid gray areas. And in this foyer, this is the area that the students avoid because it's a little intimidating, because there's a lot of information. It's not clear. It's not black and white. And so we tend to avoid it just because it feels a little harder than just, is this a good or a service or land? And so focus on the gray area, because your prof is going to give you a final exam that over tests the gray areas. Why? Because it makes for more interesting exams. It's more conducive to showing that you've mastered a challenging topic, something that's difficult, something that the average person can't do, something fitting of a lawyer. And it's a great forum to show your ability to analyze the facts and demonstrate that you can spot the relevant facts that govern this issue. And so dwell on these things and hit them hard. Whereas the black and white, the easy stuff, that's not going to be as heavily tested. And so I would say emphasize where you find a gray area, where you see something that could go either way. And the other corollary to that is don't take a gray area and make it black and white. Because I see students do that all the time as well. They say, this is clearly cakes and pies. And you're missing the ability to show your professor that you can go through the factors, you can take them through this analysis and really think and argue like a lawyer. So don't miss that opportunity.
I'm glad you mentioned that, because I think just this last time I taught contracts, I remember doing an exam review with the student. And the student mentioned how, and she probably didn't do as well as she thought she could have. I can't remember the details, but I remember one of the things we're talking about was that she had spotted all these issues, these gray areas, these debatable issues. And she had done what you just suggested you shouldn't do, which she had treated them as black and white. And I think she'd said something to the effect of, well, it was debatable. So she's like, well, I better just pick a side and move on. And she was missing the exact point. She had done a great job of spotting that it was a debatable issue, because that's really the first key thing, is that you're spotting these gray issues. You're spotting a hybrid contract. And then you see that it's a hybrid contract. And wait a second, the contract language says sale of pies, but then the person is defined as a contractor, and the labor costs are higher than the pies, than the cost of the material. So I'm confused. There's factors pulling in both directions. I'm just going to pick one and move on. And what the student wasn't realizing is what you pointed out, which is that with essay questions, a lot of what professors are doing is they are testing your ability to spot the debatable issues, then point out it's debatable, then debate both sides, and come to a conclusion which we realize is just your best guess. There is no right answer because it's debatable. You don't know what the court's going to do for sure. I mean, there are factors. Who knows if it's debatable? And that's what we are wanting to see on the essay. The multiple choice is totally different, of course, but that's what we want to see on an essay. And it is a shame to see students who they're there. They see it. They are ready. It's like a pinball game. They're ready to start racking up the points, and they turn away. And so that's absolutely correct. If you see something that looks like, wow, that's a nasty debatable issue, congratulations. You've just spotted a nasty debatable issue. You only, I guess, on essay questions in law school, you want to dive in to those nasty debate. You want to go down the trap door, go in. I know I said it was dark and scary and noisy and everyone's shouting in that hybrid contract room. I mean, you're a hybrid. Who wants to go? What? Go in there with the hybrids. You're a hybrid. I don't want to be a hybrid. You're a hybrid. Get in there. No. Yes.
You're a muggle. Yeah.
You're a muggle. Get in there and do competing arguments. So that's absolutely right. Don't avoid it. Now, what's interesting is we spent a long time talking about this, probably much longer than we thought we would. On an essay question, I spend less time analyzing this issue than the time we spent on this podcast talking about it. Is that fair? You're going to run out of time, yes. Right? Yeah. I mean,
right, exactly. You've got limited time, and so you have to do what you can, which is why it's good to issue spot in advance. But I think this is what's really helpful, I think, about the podcast is the warning of what is our human tendency is we oversimplify or we overcomplicate and we have no clarity. And I think those clear distinctions are where it's at. And I think that's the basic thing that I want the listeners to get to is how do I keep this separate from that? If I know this logic train, I keep it separate from this logic train. And all it is my job is to see it and explicitly give it to the professor. Don't keep it all in my head, because I think we store things in our heads that don't make it to the page. And I know that I had that issue long ago.
You've got to explain. We can only give you credit for what you say. Don't ever not put something down because like Professor O'Gorman knows it. I mean, you don't, or whoever your professor is. I mean, you obviously don't go overboard. I mean, I think I joke with my students. I say, if your essay starts with "since the days of Roman law," unless it's a legal history class, this is bad. This is bad. Hit the ground running, and do keep issues separate. So we've talked about that. With source of law is separate from how statute of frauds with Article 2 and $500 more. Keep those separate, but also know that when you are in the right room, you're going to have subrooms that are very gray. And so that you're going to have to do some debating and some analyzing. It's not always going to be a clear answer for sure on the essay. You want to keep it clear what room you're in. I'm in the source of law room now. I'm debating source of law. I'm not letting anything seep into this room that doesn't belong here. There's always a guy. It's like clubs. I mean, I've never gotten into a club because I never got by that guy with the velvet rope or whatever. But there's always a guy at the front, isn't there? He's a big guy. He's very intimidating, right? And that guy's not letting you in if you don't belong in that room. But once you're in that room, there's some other subrooms where it's going to be the whole room might be very gray at times. And you want to debate both sides on those gray issues, and don't be afraid. A professor here at my law school at Barry, Taylor Simpson Wood, a shout out to her. She says to students, embrace the gray. So embrace the gray. That's what it kind of goes back to. That's why you will have a job, because there is going to be gray, which means that there is a lot of shouting in those rooms, because lawyers are paid to make arguments on behalf of their client. If it was clear what the answer is, we wouldn't need lawyers. But this should probably, if it's not a hybrid, for my class, if it's not a hybrid contract, you're talking like 3 sentences. Explain. So the first issue is the source of law. Article 2 of the UCC applies to contracts for the sale of goods. The common law applies to all other contracts. Goods, I'm getting more sentences than I said. Goods are, I always underestimate how many sentences it'll take. Goods are things that are movable. This contract involves the sale of a moped. A moped is movable. Therefore, Article 2 applies. And that's it. If it's hybrid, and that should take you, honestly, that should take you like 3 minutes maybe. If it is hybrid, it's going to be longer, but still, don't let source of law in a contract class dominate. Don't let it predominate the amount of time. You like that? I've been around you too long, Steve. The amount of time your essay is. It really should be, even with hybrid, I'm thinking maybe in terms of writing time, you're still talking about maybe tops 2 paragraphs. And it's probably, I'm saying, not more than 10 minutes. Maybe it should be fast, right?
Well, and I always say, let the facts drive how much time you spend on it. If you're, let's say, if it's an early midterm, it might be more time on it. It may not be. It just depends on how many facts you have to argue. Because I let the number of facts govern how long I go on in my essay. If there's just 2 facts that are relevant, 1 fact I get in and I get out. If there's 10, 15 facts that are relevant to the issue, I'm going to be in there a while doing my thing, but I won't get out of the number of facts. If I have a lot of facts to work with, that's going to take me longer. If I have 1 or 2 facts, that's going to be really, really quick. Absolutely. Let it drive you. But in any event, at a certain point, you should know. Well, I say you should know. I mean, I don't know why students would know. But, if you're hitting at a certain point, if you've seen the length of the fact pattern and you're in source of law, and that clock's been ticking for a while, you get out of there. You just got to get out of there. Get out. Don't be a hero. Get out. Exactly. Save yourself. Save yourself. This is all about you on these. It's all about you on the exam. So a final thing on Article 2 is that, and this is a little tricky, but this is going to be good news, I think, for students, is Article 2, although it is a code, and so codes, usually you think of codes as covering everything, or that's why they're designed. Article 2 was not that way at all. Article 2, although a code, was designed to provide rules that were useful for when the contract involved goods. And so it created rules that were relevant to goods. But the Article 2 drafters knew that they were drafting against the background of the common law, that there was all this contract law already there, off-the-shelf rules.
And so the drafters did not intend Article 2 to really displace all common law. It designed to really sort of just adopt rules that were appropriate for goods. And what the common law, when Article 2 does not have a rule that governs the particular issue involved, say, for example, what's an offer, right? We'll talk about down the road what is an offer is. The common law will define an offer. Article 2 doesn't define offer. Article 2 is going to rely upon what the common law is. So when the UCC does not have a particular rule, when you're studying contracts and you've studied a section, say you've studied offer, and you've never heard anything about Article 2, you should assume that Article 2 is going to follow the common law rule. And Article 2 actually has a provision that says, in a not very clear way, that when there is no Article 2 rule governing, no Article 2 rule that will apply, speaking to this issue, apply the common law. So the vast majority of time, even if you've concluded that Article 2 applies, let's say, to a non-hybrid or even a hybrid, odds are that most of the time you're still going to be applying the same common law rules that you would apply even if it wasn't. And you just need to be on the lookout for those rules under Article 2 that are different from the common law rules.
Yeah.
All right.
I'm going to sum up succinctly. I think of the common law as the law of contract, except when the UCC is there.
I think that's absolutely right. And what your students probably want to do is they probably want to create a chart that has the main differences between Article 2 and the common law for their contracts class. You know, odds are in your contract law class, there's a chance that your professor will say, well, you don't cover Article 2 at all. I know everyone will probably applaud if they watch this video. They'll be like, oh, thank God. And they'll applaud. Most professors probably, particularly if they only have 4 credits as opposed to 6, will just touch on a few areas in which Article 2 is different. And so the good news is your chart will probably be pretty small. And you'll probably have just a handful of situations where it's kind of like these biggie, the famous distinctions. And you probably just need to know those distinctions. And so when it's source of law and you decide Article 2 or the common law, thereafter, as you run through your essay, for example, you probably just have to be on the lookout for whether any of those particular issues where there are distinctions are in play. My guess is if you get a hybrid contract, just a guess, is if you get a hybrid contract on the essay, there probably will be at least one issue down the road in that essay where it is a distinction between Article 2 and the UCC, because the professor wants to see if you recognize the significance of having gone one way or having gone the other. I'd like to make a quick mention. So Steve, you talked about sort of that decision tree at the beginning when you're in the foyer. I will mention what I like to see as a professor when there's a hybrid contract. Not if there's not a hybrid. This is only if there's a hybrid contract and it's debatable. So let's say it's not a construction job, or even if it's arguably a hybrid contract, we're going to go common law, or it's manufactured goods, even though that could be considered a hybrid contract, it's clearly Article 2. Ones where it's debatable. So like, let's say it was a complicated, you're designing something. So I'm designing a machine for you, and then I'm going to build it, and then I'm going to sell it to you. So this to me is this is ugly. We're going in down the trap door. We're going to have to look at factors. It's going to be debatable. I don't care when it's debatable. I don't care which conclusion you come to as long as it's supported. It's not so much about the conclusion. It's about the journey. Have you identified the factors? Have you made competing arguments? Competing arguments is very important. I'll never forget, I was studying for the bar exam, and the person, one of the people doing one of the lectures said, well, you know, what they don't tell you in law school is that one of the keys to success is arguing both sides. And I remember that's the first time I'd ever heard that. And I was studying for the bar. I'm like, really? Really? Now I learned that? Can we hit the rewind button?
Get your money back.
Right? So I guess the statute of limitations is run. So no, I had a very good education where I went. I loved my law school, but it would have been nice if I had been told that in advance. So a lot of it is making those competing arguments, not so much about the conclusion. If you get a hybrid contract and it is debatable, I at least like to see, like, let's say that there is an issue down the road where the UCC and the common law splits. Now, this is a very difficult move. This is kind of like in the Olympics, you know, where they say, don't they have like levels of difficulty? And can you pull it off? And a lot of times it's like, look, don't try to pull it off. But what I really like to see, and I've only seen this in my career a couple times, is where the student knew it was a debatable conclusion on source of law, and they then come to an issue of law that they know has a different Article 2 rule and common law rule. They actually they remembered. They haven't just gone on the article. Let's say they picked Article 2, but they knew it was, they were standing at the crossroads and they're like, oh, that's a head scratcher. But I'm going to make a prediction, and I'm going to predict it would be Article 2. They know, they remember standing at the crossroads and remembering that they were looking left and looking right and looking left and looking right and arguing, talking about looking left and looking right in their analysis. And they knew how hard a choice that was. That when they get to an issue where they then know, wait, this is one of those issues that was on my chart, Article 2 versus common law. They remember the difficult choice they made in the foyer. And they then say, well, I predicted that Article 2 would apply. And if that's true, this is the rule. But it's not clear that Article 2 would apply. And if it doesn't, then it would be this rule. So I completely agree with you that you certainly don't, like, let's say if it's a simple sale of goods, it's clear whether it's Article 2 applies or it's clear it's a common law applies. Please do not be talking about, well, if this had been the sale of a moped instead of a sale of land, you're killing me. Stop. Because now you're just sort of explaining law to me. You're not analyzing the fact pattern.
Or you're just making up a fact pattern or giving a hypothetical back to the professor, which is like, that's their job, not your job.
I once had a student say, well, it didn't mention that the parties were drunk, but if one of the parties had been drunk, they might be able to get out of this on intoxication. I'm like, really? I can't even remember, was the contract at a bar? Maybe then it's at least a little forgivable, but yeah, please don't be like, if the offeror had died, no one's dead. I didn't say he died. But if it is debatable, so you don't want to be doing that. But if it was debatable at hybrid in the foyer, so to speak, I do like, because it shows, boy, that shows skill and memory to come back and then bounce back and forth. So I agree with you where you said, watch out. Don't be bouncing a bunch back and forth. And certainly don't be bouncing back and forth every time. Like, oh, let's talk about what's the predominant purpose again? Get that out at the outset. But if you've got it out at the outset and it was debatable, kind of coming back and mentioning what the different result would be if you'd taken a different road that you traveled, that can be awfully impressive.
And think about your job as a lawyer. Would your client be ticked off at you if you didn't give them a heads up that if we lose on this point, we're going to lose the whole thing? If we win on this point, then we're going to win the whole thing. If you didn't have that ability to advise your client, you'd be screwed.
But I really thought that Article 2, I was so sure.
Yeah.
I was so sure that the court, I did the factors and like they seem to go this way. Yes, no, you got to be prepared that when it's hybrid, you got to know. Look, if there's a fight in a case over a hybrid contract, it's because it matters what law applies in the real world. And you've got to be prepared to shift and know what's going to be the result. If you're just predicting which way it's going to go, let's say on the hybrid, because it's complicated, let's say, you got to know what the different result would be. And yeah, mentioning that in your essay is awesome. Very hard to do. Well, so the common law. So we've talked a ton about Article 2, probably way more than is in some respects important in your conscious class, because most of your stuff is going to be the common law. And think of the common law applying when Article 2 doesn't. Steve, you mentioned, you were absolutely right when you said, common law is the law of contracts unless Article 2 applies. But in some respects, we kind of default into the common law because Article 2 actually tells us when it applies, sale of goods, and everything else, the remainder is the common law. So in some ways, the way we talk about it is backwards from the way it should be, which way you mentioned it, but we kind of back into the common law by deciding that perhaps there are no goods involved and therefore it is the common law. But that's a big residue of stuff. So things that are not going to involve goods are services. There's no goods. So when Steve does finally get a job, Steve will be providing the services of human capital. I'm between jobs too, because I'm not on contract, right? We do 9-month contracts. So we're both between jobs. So when the academic year starts again and I'm employed, do you know how you know when you're on contract as a faculty member. Steve, do you know how you know when that date starts?
It's you get emails.
A faculty meeting.
Okay.
Faculty meeting. So yeah, so that's when you know you're back on contract. And so services, employment, you know, so what Steve does for Miami, what I do for Barry, employment, services, that's not goods. We are tangible, but what we're doing, the services are not tangible. They're not things that are movable. So club membership is an example too. Construction, as we said, building, the act of building, that is a service. That's going to be common law. Land, talked about that. Sale of land. Land is not movable. Do not think it is. If I sell you gravel, well, that's movable, or the wheat, but land is an invisible boundary. So the land that I own around, which my house is on, is technically, it's not movable. It is a boundary line, right? I mean, I guess there's a plat somewhere, isn't there, down in some government agency where I can go and look at it. It's an invisible boundary line. And so that's why land itself is not movable. We talked about money. Money, if it's for the sale of goods, it's the price. It is not considered. Yes, it's movable, but it's specifically exempted from the definition of goods and intangibles. So intellectual property, I'll sell you my copyright. I'll sell you this trademark, a settlement agreement. These are something called chosen action, which is probably way too complicated for this session, but chosen action, which is like a legal entitlement or right. So I have a right to sue you in tort for the injuries you called me. You enter into a settlement agreement. Unless you're selling goods, like I'll waive my claim against you for your car. That can happen. It's unusual. That is not a contract for the sale of goods. So all of those things are not covered by Article 2. And we would be remiss, would we not, Steve, if we didn't mention, I think, the restatement second of contracts.
I love restatement. That's one of my favorite things.
Wow. Has that sentence ever been said in the history of broadcasting or whatever we're doing? Wow.
It was kind of the cheat guide. They pulled, correct me if I'm wrong, but they pull the rules out of the cases for you and put it in a book. And I loved it for that. It just made it so easy. It jumped out to bite.
You are absolutely right. So the restatement of contracts is just that. So the restatement of contracts is a project. Restatements, there's a lot of restatements. There's contracts, there's torts, property, agency. The restatements were created by one of the bodies that was involved with drafting the Uniform Commercial Code, the American Law Institute. So yeah, these people, they love this idea of like making things clearer. And you know, we have 50 states. So not only do we have 50 states with different commercial laws, so let's create a uniform commercial code and try to get states to adopt it. They figured that I guess they figured, I'm just kind of making this up, but it seems right. They probably figured, well, we can't get states to all adopt just a code of contract law. So your hope was dashed, Steve, right? I mean, come on, we're not a civil law jurisdiction. So that was hope was dashed. So they got the commercial laws of statute, but they didn't give up. They were an industrious bunch, and they figured, well, you know what we can do is we can draft a restatement of the law, which is specifying what we think the law is that most states are doing. We call these the majority rules. What most states are doing, and we'll create a bunch of books. Oh, I didn't bring one. It's called the restatement of whatever. And this is a restatement of contracts, and it would have the Blackletter rules all listed in there. And we're not asking anyone to adopt them, though I think the Virgin Islands did briefly. We're not asking anyone to adopt these. We want to adopt these and let you know what we're gonna do the hard work for you guys, the courts. We're gonna look at the state law, extract the rules from the cases, identify what we think most states are doing, put that all together in a restatement of law, and we give it to you. This is take it, use it. If you adopt our Blackletter restated rules, we're thrilled. We want you to. We're encouraging you to. And every now and then, the rules were aspirational. So we'd like to push it a little in this direction. But the vast majority of time, it's called the restatement. It was restating the law. And so what's great for students is the restators have identified, and for professors, have identified what most states are doing. And so what professors and students can do is, instead of kind of throwing their arms up in the air because they have 50 states with 50 common law contracts, right? And they don't have an Article 2 of the UCC where everyone's adopted, almost everyone, Louisiana accepted, adopted the same statute. The hope was that this at least would create some sort of uniformity. Courts would start to rely upon, as part of the common law, would rely upon the restatement, and it would create greater uniformity in contract law. The restatement is not binding because it is just suggesting to the states, not that the legislatures adopt them, though they certainly could if they wanted to, they haven't, suggesting to courts what the law is that most states are doing, and encouraging everyone to adopt through the courts as common law, sort of the same rules of law. So that we call the restatement what we call secondary authority, which means it is not binding, as opposed to so-called primary authority, which, like Article 2, unless you're in Louisiana, is binding. But the restatement, I sort of treat the restatement, and not all professors do, and a lot of professors really don't like this, but I treat the restatement as sort of law, because we want to be all on the same page. We got 50 states and a survey class for contract. We can't spend a lot of time worrying about what Nebraska is doing and Illinois is doing and Florida is doing. There's just not enough time for that. So I rely heavily on the restatement as the source, as correctly identifying what the common law is. And so in your course, if you see a lot of references to, citations to the restatement second of contracts, just remember it's not law, but there's a good chance that, your professor is using that to indicate what most courts are doing, and would expect you to follow what their statement is doing. Again, depends on your professor. But what I wouldn't say is, I wouldn't say the restatement of contracts is law. So on that, when you're in the foyer and doing source of law, please don't say, well, Article 2 of the UCC, say this, Article 2 of the UCC applies to contracts for sale of goods, and the restatement applies to contracts that are not for the sale of goods. Because what you're now suggesting to your professor is, it's almost like you're suggesting, whether you intended it or not, that you somehow believe that the restatement of contracts is in fact law, as opposed to simply restating what the law is. I would just say the common law applies to contracts that are not for the sale of goods. I don't even know that you ever need to mention the restatement in your essay answer. You're just using the rules from the restatement throughout. You're using it as to help you identify what the rules of law, the common law are.
It's interesting. I go back and forth. I completely agree with you, and I've seen faculty who don't want you to cite the restatement at all. But I always thought it was ironic when the restatement is just pulled from case law, whereas if you just cited the case, that's law in that jurisdiction. And so it's frustrating to see how the restatement gets dragged through the mud, when it's really just, we're pulling the law from this jurisdiction and putting it in here. Now, I can see a better argument for those aspirational aspects that are not law anywhere, that are just trying to move the law in one direction or another. I see the argument there, but anyway, this isn't about the restatement. But
yeah, you ask a contract professor about, you just say something like that to a contract professor, you're just begging me to comment on it. But I think, so maybe a final note, a lot of professors probably are bothered by students suggesting that the restatement is law, or treating it like a code, because it is antithetical to the fact that it is restating the common law. The very notion of the common law is that it is flexible. It can change. The courts can decide that the current rule of law, they don't like it anymore and they want to shift. You can't do that with a code. A code is the legislature. The legislature can change it, but the courts can't change the code. The common law is the court's baby. And so if the courts want to change a common law rule, you got to follow, if you're a lower court, now this is getting a little bit more into court hierarchy, but if you're a lower court, you got to follow what the higher court says. But if, say, the Georgia Supreme Court decides that they want to add an element to the defense of misrepresentation, they can do that because it's the common law, it's not in the code. And I think the concern is from professors is that they don't want students believing and treating the restatement like it is a statute, like it is a code, because it is not. It's flexible. Now, my thought on this, though, is okay, fair enough. But on a law school essay answer or on the bar exam, I doubt it's a good idea to be trying to argue that the rule should change. You're probably being asked to apply existing law. So in some respects, treating the restatement, if it is an accurate statement of existing law, and it's getting a little long in the tooth, I mean, it's 1981 for the second restatement of contracts, but contract law changes are like, it's like, I don't know, it's like, going from the ice age to whatever. It's like glaciers moving. It's very slow. It hasn't changed all that much in all honesty in probably the past, 150 years. And so in taking a law school exam in 2021 in contracts, treating the restatement rules as law, although they're not, is, in my opinion, probably not a terrible law school strategy, as long as you don't suggest to your professor that you in fact think it's law, and you don't say, don't act like you're treating it like a code. So in some respects, I think you kind of want to like balance things. You want to both apply what the current law is, and their statement is giving you a pretty good indication of what that is the vast majority of the time, while also sort of doing a little nod to the other way, to acknowledging that, hey, I'm not in any way suggesting that the restatement is law, that the common law is any way solidified, because that's totally antithetical to the common law. That's what makes it different from the civil law system. But so expect, in many of you out there, your professor will rely heavily on their statement of contracts. And that's a good signal, right? I mean, Steve, you talked about signals from your professor. And if your professor is talking a lot about the restatement and maybe recommends the restatement of contracts as a supplement for you to use in the course, or maybe it's required, or citing to provisions, that's a pretty good signal that your professor is on board with using the restatement as a strong, not binding, but as a very strong source of what the rules are. And if you never hear the professor talking about the restatement ever, maybe it's better than, well, what's he or she focusing on, the cases, and maybe not relying so heavily on the restatement. Would you say, is that fair?
Absolutely. It's all about getting to know, how your prof runs things and what they like, because the professors that I know who are hostile toward the restatement make it no secret. And so you should know it as a student in the course.
Indeed. All right, Steve, I think we've talked more than long enough about source of law, since we thought this would take half an hour. Any concluding thoughts on source of law before I stop this recording?
Nothing. I think you've done a great job.
You think we're going to get picked up?
I think Netflix is going to sure pick us up.
I hope so. So hopefully
we're better than Adam Sandler, aren't we?
Adam Sandler, I believe, came into my law school library. That's a story down the road. Yes.
Oh my God.
I think I may have shushed him. Yeah, he was very noisy. He was kind of noisy in there. I don't know.
Oh, wow. It's like you turned him away at a Waffle House, or what was it, IHOP or whatever. That just happened a couple.
Oh, I did not know that. Yeah, I don't know if it really was him or not. He probably was being very funny. I probably was like the party pooper, right? So I was starting to study. I was a Lunel. I was stressed. I apologize. All right. So that is it for episode 1 of our Blackletter Law series of K-Talk. Hope you enjoyed it. Hope it was beneficial. I think now is when I say we encourage you to like and subscribe. I don't know what any of that means, but I think that's what you say.
Ring the bell. Ring the bell. I don't know what that means either, but do that.
Yes, like and subscribe, and hopefully we will see you on the next episode.